Let's now look at how to answer some contract law questions. When you look at a question like this, which is found in the contract overview document, this is usually a 5-mark question. It will be stated in the exam how many marks are allocated to each question. And if this question is 5 marks, you should be spending only 5 minutes at it. That means you'll have to spot very quickly what the issue is. When you look at the question, it states here, Jack offers. So the question then is, does Jill have a valid contract? This means that you need to have a look at the law that relates to offers and valid contracts. Fortunately, if you have an overview, it will all be there. And you can look at the items about offers. When you read this and says that Jill says she will only buy it for $40,000, you can recognize that this is actually a counter offer. What's the effect of the counter offer? When we look at this, we can see that a counter offer ends up in the offer being terminated and there's no contract. So this is the statement of the law. You can actually look, because this is an open book exam, you can look at your lecture notes and you can say that the law states a counter offer will terminate an offer and there will be no valid contract. This is your statement of the law, and you need to give the authority. The authority is the case of hide and wrench. So you would say a counter offer will terminate an offer and there will be no contract. The authority is hide and wrench. That gives you 2 marks. What about the other 3 marks? Let's go back to application. In this case, Jack has made an offer and Jill has made a counter offer. Jill's counter offer terminates Jack's original offer. Therefore, Jill cannot accept the offer later because the offer has already been terminated. This is your application and this is 2 marks. Your conclusion is the last mark you have. Does Jill have a valid contract? And the answer is no. Jill does not have a valid contract. 2 plus 2 plus 1, 5 marks. To illustrate again, let's have a look at another discussion question, the one at the end. This is also going to be a 5-mark question. Mary the singer signs a contract with George to sing at George's event. The terms are 3 days rehearsal and 1 day to perform at the show. Mary falls ill and misses 2 days rehearsal, but is ready for the 3rd day, but George no longer wants her to sing. Can George treat the contract as discharged? When we look at this, we know we need to look at our notes and the areas of discharge. And when can a contract be discharged? There are 2 ways that contracts can be discharged that we know. With a breach or without a breach. And we know that some breach has happened. Because it's not performance, it's not agreement, it's not frustration. There's actually a breach. The question is this breach serious enough for the contract to end? And there we look and see if the terms are very important, they're called conditions. And a breach of condition means the contract can end, meaning be discharged. But terms which are less important are called warranties. And a breach of warranty means the contract must still continue. It cannot be discharged. So let's know that this is actually the statement of the law. Statement of the law, which is that if it's a very important term, it is a condition, and the breach of a condition can discharge the contract. But if it's a less important term, it's only a warranty. And a breach of warranty does not discharge a contract. The contract must continue even though the defendant must pay damages. So let's apply this and we look at the facts of this question. And in fact, here are the terms. 3 days rehearsal, 1 day to perform at the show. Mary has breached the term of 3 days rehearsal. Now, is this an important, very important, or less important term? We can actually argue that the rehearsal is the less important term. The most important term is the day to perform at the show. We say that this is the less important term, by breaching this warranty, she has to pay damages, but the contract will not be discharged. So that's if we consider the 3 days rehearsal to be a warranty. Now, could you say that the 3 days rehearsal was a condition? It's less convincing because even without the rehearsal, she may be still able to perform. She might not be performing as well. Then George can get damages for that, but she should still be able to perform. So this is really for something you need to argue. If you really have a convincing argument that the 3 days rehearsal is a condition, then I will consider that as well when I'm marking. But for now, we take the 3 days rehearsal to be a warranty, so the contract cannot be discharged. So conclusion, George cannot treat the contract as discharged. Okay, here's a bonus part. Sometimes people make a mistake and they say, is this frustration? Here's the thing, if Mary falls ill and misses 2 days of rehearsal but is ready for the 3rd day, this does not prevent the contract from carrying on. It doesn't prevent the contract from carrying on. She's still there. She has still come back. The frustrating event must be something which actually prevents the contract from carrying on. For example, the entire concert hall burns down. Then you really can't carry on. That's why this is not a frustration question. This is a breach of condition or breach of warranty question. So use these principles. Make sure you keep your answers to the point. Answer a 5-mark question in 5 minutes. And you keep this up and you'll be able to be okay. Understand make sure you're familiar with all your lecture notes and slides so that you can get to what you need quickly, and I wish you all the best for your exams.